Hello there. This is again your friend Dean Joe-Santos Balagtas Bisquera, bringing you this time the corporation, the revised corporation code, and we will focus on the board of directors or board of trustees. With your kind permission, allow me now to dedicate this and give tribute to the leadership of the University of Manila. And I'd like to, with a lot of personal emotions, give a salute to three of my fellow workers at the highest levels of the University of Manila. Dr. Emily Dadson de Leon, President and Chief Academic Officer, Dr. Maria Ramona Corazon de los Santos, our Chairman of the Board of Trustees and Vice President Treasurer, and on the side, the controlling stockholder of the University of Manila. And my dear friend, Attorney Diosdado Madrid, our Corporate Secretary. Even when I have spent 27 years at the University of Manila, my experience with this wonderful school dwarfs the experiences and stay of Dr. Emily Dadson de Leon, Dr. Maria Ramona Corazon de los Santos, and Attorney Diosdado Madrid. Dr. Emily Dadson de Leon must have spent her 47 years from the time she was a very young and charming lady who joined the University of Manila. Dr. Ramona Corazon de los Santos has spent 5 decades of her life, almost her life, because she was born and started running probably in the campuses of the University of Manila, being the youngest daughter of the controlling stockholder then, Dr. Virgilio de los Santos. And Attorney Diosdado Madrid has been a very loyal supporter of the University of Manila, having occupied a number of legal positions, but for years was the trusted corporate secretary of the Board of Trustees. And I owe this particular opportunity to dedicate the discussion on the revised corporation code concerning the board of directors or the board of trustees. I have the privilege to be part of the board of trustees of the University of Manila, headed by Dr. Maria Ramona Corazon de los Santos as chairman of the board, President Emily Dadson de Leon as the president, and Attorney Diosdado Madrid as the corporate secretary. So without much ado, we now go to the discussion of the revised corporation code on the Board of Trustees. We have the following list of subject matters that we will take up, and they're numbered according to the articles in the corporation code. We will talk about the board of directors or trustees of a corporation, the qualification and term. We will go to the election of directors or trustees, the corporate officers, the report of election of directors, trustees, and officers, and the non-holding, if ever, of the election and the cessation from office the report going to the Securities and Exchange Commission. The disqualification of directors, trustees, and officers, removal of director or trustee, vacancies in the office of director or trustee, emergency board, compensation of directors or trustees, liability of directors, trustees, or officers, the dealings of directors, trustees, or officers with the corporation, the contracts between corporations with interlocking directors, the disloyalty of a director, and the executive, management, and other special committees. We will follow the format where we will have this topic, and this particular little circle here would allow me to click it to go to the slides that would discuss this particular board of trustees, for example. And then at the end of the couple of slides that were there will be this big circle at the bottom right-hand portion to say that that would be the last slide for the topic, and therefore when I click it, we go back to this particular master schedule. Let us try doing it now with the board of directors or trustees of a corporation, qualification, and term, and let me click this now. There you have it, the board of directors, and it says the corporate powers and control. The board of directors or trustees shall exercise the corporate powers, conduct all business, and control all properties of the corporation unless otherwise provided in the revised corporation code. Directors shall be elected for a term of 1 year from among the holders of stocks registered in the corporation's books, while trustees shall be elected for a term not exceeding 3 years from among the members of the corporation. Take note that for stock corporations, the directors will hold a 1-year office, but for the non-stock corporations, the directors or trustees will hold 3 years. Each director and trustee shall hold office until the successor is elected and qualified. So this is the holdover principle. So there will not be any situation in a corporation where a position of a director would be left hanging. A director who ceases to own at least 1 share of stock or a trustee who ceases to be a member of the corporation shall cease to be such director or trustee. The board of directors has legitimate power and control over corporate administrative matters. Contracts entered into by the board are binding upon the corporation unless such contracts are so unconscionable and oppressive as to amount to a wanton destruction of the rights of the minority. And an action of the board during a meeting, illegal for lack of notice, may be ratified. So if a board meeting was called but there was no notice, legally, the board meeting has no legal effect or it cannot be binding. However, it is possible that in the subsequent board where there is already the usual notice and there is a quorum, that subsequent board meeting can ratify the previous meeting where the notice was not served by the action of the directors in subsequent legal meeting or impliedly by subsequent corporate conduct. In effect, this corporate conduct will bring about the a situation where by failure to raise any question on a board meeting where the invitation or the notice was not given out, that can be ratified either by the subsequent board or after a little while when nobody questions that specific meeting that conceptually has not been properly called, then the failure of the board of directors to raise the issue will become, in effect, estoppel. It is almost like an implied acceptance that that particular board meeting where there is lack of notice would have been considered already impliedly ratified. You will notice that whenever we flash some portions of the slide with italics or something like a handwritten thing, this would represent the provisions in the original corporate code, Batas Pambansa bilang 68 of May 1, 1988. And so before the revised corporation code of 2019 was enacted, what was in place in the area of the board of directors is the corporate powers of all corporations formed under this code shall be exercised. All business conducted and all property of such corporations controlled and held by the board of directors or trustees to be elected from among the holders of stocks, or where there is no stock, from among the members of the corporation, which shall hold office for 1 year until their successors are elected and qualified. And there is that little footnote 2, which corresponds to this, which says Section 23, Corporation Code. For purposes of facilitating, we will have this particular disclosure every now and then in the slides, but so as not to burden unnecessarily our pace, we will just show it quickly and we will no longer discuss it the way I'm reading it now. Continuing, every director must own at least one share of the capital stock of the corporation of which he is a director. And that is also essentially here. Which share shall stand in his name in the books of the corporation. Any director who ceases to be the owner of at least one share of the capital stock of the corporation of which he is a director shall thereby cease to be a director. Trustees of non-stock corporations must be members thereof. A majority of the directors or trustees of all corporations organized under this code must be residents of the Philippines. Take note, because of technology, because of the advances in communication where you can even conduct meetings online, the requirement of the board of directors or trustees to be residents of the Philippines has been eliminated under the revised Corporation Code of 2019. Take note of that. Continuing now, corporations vested with public interest. This one is relatively new in the revised Corporation Code. Under Section 22, it provided that the board of the following corporations vested with public interest shall have independent directors, constituting at least 20% of such board. The first corporation considered as corporation vested with public interest would be letter A, corporations whose securities are registered with the Securities and Exchange Commission, corporations listed with the stock exchange or with assets of at least 50 million pesos or having 200 or more holders of shares, each holding at least 100 shares of a class of its equity shares. The second corporation with public interest are banks and quasi-banks, non-stock savings and loan associations, which we will henceforth abbreviate as NSSLA, non-stock savings and loan associations, pawn shops, corporations engage in money service business, pre-need, trust and insurance companies, and other financial intermediaries. The third, corporation with vested with public interest would be other corporations engage in business vested with public interest similar to A and B as SEC determined, after taking into account relevant factors germane to the objective and purpose of requiring the election of an independent director, such as the extent of minority ownership, type of financial products or securities issued or offered to investors, public interest involved in the nature of business operations, and other analogous factors. Independent director, corporations with public interest. An independent director is a person who, apart from shareholdings and fees received from the corporation, is independent of management and free from any businesses of other relationship which could or could reasonably be perceived to materially interfere with the exercise of independent judgment in carrying out the responsibilities as a director. To be very candid about it, for corporations listed as letter A, B, and C, those that are, for example, with securities registered with SEC, which are listed in the stock exchange, or those with assets of at least 50 million and having 200 or more shareholders, banks and similar organizations. Our policymakers, our legislature, has decided to bring in to the corporation, to the board of directors, representing 20% of that board. No? So you have, for example, if you have 5 directors, well, 10% is only one half. So 20% is one director in a board of 5 directors. The corporation code now requires that that particular director is an independent director. He is not essentially intertwined with management. He has his own view on what to, how to look at the situation, so that in effect, if you would like to introduce the concept that he can act as devil's advocate. And so this will therefore be a check and balance and therefore provide independent judgment. Of course, this is a very difficult thing. The personality of that particular person can be so obnoxious that he becomes, in effect, the son of a bitch in that particular, in the board meetings. But if he knows how to handle himself so that he focuses on major issues rather than, on the pettiness of things, then he can actually be a constructive member of the board of trustees or the board of directors, because he can point out certain loopholes wherein, for example, a board of 5 members, essentially if all of them are thinking in the same direction, because essentially they belong to the same group of majority stockholders, then it is possible, that they are honest and candid and in good faith in thinking about a certain corporate course of action. However, when you do not have an independent director, the way it is being prescribed in these organizations, there is no input by which somebody may see a certain risk or danger that the other 4 may not see. And if this independent director knows how to handle himself, he probably will not be like a fiscalizer and says, I object, things like this. He probably will ask very friendly questions in terms of a tone that will allow the other directors to start thinking differently. And this is therefore the value of an independent director. More so in the concept, like for example, of banks and other financial institutions which accept money from the public, similar to these corporations. And therefore, these corporations have a very tough trust function, insofar as the monies that they receive from the investing public are concerned. And so, any extraordinary risk-taking may be worth it, except that if you have an independent director, he might be able to point out the possible negative consequences of such a course of action or a strategic trust. As I was saying, he can be the devil's advocate without acting like the devil himself. Continuing now, the independent directors must be elected by the shareholders present and entitled to vote in absentia during the election of directors. So you see, there is an acceptance by the other members of the board. This is not a director who's put there like a real security guard or somebody who's like a member of the Central Intelligence Agency watching every move of each of the directors. No, the other directors must receive him, with welcome hands, recognizing that his independence might in fact improve their own strategic trust. Independent directors shall be subject to rules and regulations governing their qualifications, disqualifications, voting requirements, duration of term limit, maximum number of board membership, and other requirements that the SEC will prescribe to strengthen their independence and align with international best practices. It just came to my mind that if you have a board of directors and you have an independent director, take note that there is a requirement that the minority shareholders are supposed to be represented also in the board. And so now, if you are a director representing the minority shareholder, you would no longer be so alone. You will no longer be so overwhelmed by the tyranny of numbers when certain critical strategic issues are being discussed. The independent director may tilt the balance in favor of some very strong personalities in the board, which is typical whether we talk about a board of Filipinos or a board of foreigners. We now go into the election of the directors or trustees. First, there has to be a quorum, and the owners of majority of the outstanding capital stock represents the quorum. They must be present in person, or they must have a representative with a written proxy, or a member voting through remote communication or in absentia. So there are three types of stockholders who may in effect elect the board of directors. The words, and they have to comprise the majority of the outstanding capital stock. So if there are, for example, 1,000 shares of stocks outstanding, the majority will be 50% plus 1. So 50% of 1,000 is 500. There has to be 501 shareholders who are participating in the election of directors constituting a quorum. And to call for a quorum, there are three types of stockholders who may be counted as part of the quorum. Obviously, the one who is present in the election of the board of in the board and in the stockholders meeting to elect the board of directors. This is a stockholders meeting electing the board. And obviously counted are those who are physically present. Second, those that may not be physically present, but they have the representative with a written proxy. And third, they may not be physically present, but they're linked up through the online facility of what we have now in the internet. At all elections of the directors or trustees, there must be present either in person or through representative authorized to act by written proxy, the owners of majority of the outstanding capital stock, or if there be no capital stock, a majority of the members entitled to vote. When so authorized in the bylaws or by a majority of the board of directors, the stockholders or members may also vote through remote communication. So take note, the remote communication requires, the provision in the bylaws to allow them to vote on remote communication. Or the majority of the board of directors, meaning the existing board, because you have not yet elected the new board. So the majority of the incumbent board of directors or the stockholders, and the majority of the board of directors allow the voting through remote communication in absentia. Now, the right to vote through such modes may be exercised in corporations vested with public interest, notwithstanding the absence of a provision in the bylaws of such corporations. Now, take note of this one. An ordinary corporation will not allow a member to vote through remote communication who is in effect in absentia. If the bylaws did not provide for it, or if the board of directors, majority of the board, did not vote for it. The exception is in the case of corporations with vested public interest. Even when there are no provisions in the bylaws, well, it does not say that if there are no approvals by the majority of the board, the presumption is there may not be a provision in the bylaws allowing for voting to remote communication. But the existing board of directors may vote to grant them the right to vote in remote communication. A stockholder or member who participates through remote communication or in absentia shall be deemed present for purposes of a quorum. So, for purposes of saying, do we have a quorum? Those who are allowed to vote by reason of the bylaws provision or by reason of the consent of the board of majority of the board of directors will be counted in the quorum. And so the corporate secretary will list down the names, and if I were a smart corporate secretary, I will list down the names according to these categories. So I will list down the stockholders who are present, the stockholders who are voting by written proxy, and the stockholders who are voting by remote communication. Well, this is the old provision under the Corporation Code of 1980. And as what we have agreed, unless there are any changes between that particular provision and the new provision, or unless there are any clarificatory questions later, we will not touch anymore on the historical provision. Now, allow me just to make my picture a little smaller so you can see the provision. All right. Nomination. Each stockholder or member shall have the right to nominate any director or trustee who possesses all the qualifications and none of the disqualifications set forth in this code, except when the exclusive right is reserved for holders of founder shares. Well, just to revisit founder shares, there are corporations where they say that the election of the board of directors is limited to a certain group of shareholders holding what are called founder shares. So in those corporations, and the corporation code now has limited the exercise of the exclusivity in the votation for the board reserved to the founders only for 5 years. After 5 years of the founders' shares, they will no longer have a monopoly of the election of the board of directors. However, when the founders' shares are in the articles of incorporation, during the first 5 years of the corporation, the board of directors is only elected by those who hold the founders' shares. We move now to balloting. As we know, every election has to have a ballot where the choice of the voters would be placed. The election must be by ballot if requested by any voting stockholder or member. Take note of this, from parliamentary procedure point of view. If there is no voting stockholder who moves that the election be held by ballot, by secret ballot, then the option of Viva-Voce can happen. What is Viva-Voce? One of them is the raising of funds. So there will be a nomination, for example, of 5 members of the board of directors. And after the nomination for the 5 have been made, there were already 5 names, a smart group may move, for the closing of the nomination. And so if the nomination is closed without any objection, from the floor, from those stockholders attending the election, then that means you have 5 positions and there are only 5 nominees. Then there is no need for you to cast a ballot because all of them, even if they get only 1 vote, would have been counted to be elected. And so that is a usual procedure in very smart corporations where a certain group is strongly controlling the board. Except, of course, the independent director. But even the independent director may be nominated among the 5. So, for example, it is Francisco, for example, Pedro, Jose, Ernesto, and for example, Virgilio. And there are only 5 directors to be elected, and after the 5 have been nominated, somebody stood up and say, Mr. Chairman, I move that the nomination be closed. And so the requirement of balloting will no longer be necessary. That will be a superfluous event. Because if you are only voting for 5 directors and there are only 5 nominees, obviously they will be counted as vote. Of course, there will still be, the usual parliamentary procedure will be there is a motion to close the nomination. Any objection? Hearing no objection, the nomination is closed. Let us now proceed to voting, the chairman will say. And somebody will now take the floor and say, Mr. Chairman, since there are only 5 positions of directors available to be filled up, and there are only 5 nominees, may I therefore move that these 5 nominees be automatically declared as unanimously approved. And so therefore, there is a second motion, and the chairman says it has been moved and seconded that those who are nominated would fill up the position of directors. Are there any objections? Hearing no objection, the chair declares that the 5 nominees are duly elected as board of directors. So no balloting. Okay. However, there will be some areas where there can be certain conflicts. Like you always know that there will always be a minority and a majority shareholdings. And so after the 5 have been nominated, and there is absence of a minority, a representative or nominee from the minority shareholder, when there is a motion to close the nomination, then any stockholder, and expectedly those representing the minority will say, "Objection, Your Honor, we would like to make our own nomination." And the chair is bound to recognize the additional nomination. The nomination can now be made. I nominate, so there will be 6. I nominate, 7. Okay. And after a while, Mr. Chairman, we have now 7 nominees available. May we move for the closing of the nomination. Yan. Okay. Now, of course, in typical elections, we know that there are certain ceremonies where perhaps some of the or the nominees will be asked to say a few words. That's not while it's not provided for here as a matter of practice and as a matter of courtesy, that is allowed. There is nothing about that. Now, the only problem is when you have a nominee there who happens to be representing the minority shareholder, he may go into a 5-hour filibuster, and so what happens now? Well, for smart chairmen, they will have their own people to say that after giving due respect, who knows, 5 minutes, 10 minutes. In fact, the chairman may even say we will allow every nominee to speak for no more than 5 minutes. Then after 5 minutes, the chairman may warn somebody is filibustering, Mr. Stockholder, we would like to remind you that there is a standing agreement or resolution to limit the talk to 5 minutes. But we would like to give you another extension of 5 minutes. Okay? And after that, we will already proceed with the election. That is how normally these things are done. Unfortunately, this is not normally studied in law school because these types of proceedings are what are called parliamentary procedure and therefore is not covered in any of the subjects in the College of Law. These are normally learned. The authority here, when I was still a student leader, is what is called Robert's Rules of Order. People like Roberts develop a certain kind of mechanism or procedure in deliberative bodies so that there can be no confusion anymore. That is the reason why normally you see the chairman behaving in a certain pattern, like even the preparation of the agenda. But in the matter of unnecessary arguments and debates on the floor, there are certain techniques in Robert's Rules of Order that allow the chairman to cut short the seemingly unending debate and proceed with the business of the day. You will hear, for example, some people making motions. Like a while ago, Mr. Chairman, we moved for the closing of the nomination. That is a motion under parliamentary procedure. And there can be an objection under parliamentary procedure, objection, Your Honor, and so on. And so the chairman would have his set of rules to follow whenever members of the deliberative body would raise this question. I have a very exciting experience just recently. I did not realize that our friends in the military are probably also frustrated lawyers. And so whenever they have their alumni association, they would have certain groups of people who behave like, lawyers, fiscalizers, and things like this. And some, leadership have some problems because some of their members are smarter in parliamentary procedures. So as a consultant, I was asked to help out, and I guided some of their leaders to accelerate. Like one example is there is an ongoing debate, or that particular, let's say there is a motion, and it will tend to invite extensive debates. And so the motion is presented, seconded. Now the chairman can adopt some smart moves and say, there is a motion properly seconded on the table. Now, if he opens the debate, then that can prolong the meeting. And so I advise the presiding officer, sir, you know, the way to cut the debate would be, you say there is a motion duly seconded on the table. Are there any objections to the motion? Now, the people who wanted to argue may not know what to do the moment the chairman says, are there any objections? And they were not listening, so the chairman can bang the, you know, that's the one of the purposes of the gavel. Hearing no objections, the motion is approved. Pak! And then they realize, uy, nalusutan tayo. So I say, Mr. Chairman, we move for a reconsideration of that particular motion. Okay. Well, the chair already has ruled because there were no objections when I said any objections. So I ruled. But Mr. Chairman, we would like to appeal to the ruling of the chair. And I always tell my clients, watch out. If the assembly would like to reconsider what your ruling is, that requires 2/3 vote to overrule your ruling. And so you can insist on your ruling, and in the matter of insisting on the ruling, you know, it will be very difficult for them to get 2/3 vote because there will be a need for nominal voting. Normally, the voting happens this way. Like there is such a thing as Viva-Voce voting. The Viva-Voce voting can start with as many as in favor of the motion say A. Okay. And you know, the crowd says A. As many as not in favor, or again, say nay. Say nay. And normally, you know, if you have a big crowd, you know, they can always shout A's, and therefore you win. And so the chair would say, well, the A's have it, the motion is carried. Then somebody will say, Your Honor, I would like to move for a reconsideration. We would like to ask for a raising of hands. That's still Viva-Voce, but raising of hands. Again, that can be, you know, and there will be counting. And the third option is what is called nominal voting. Your Honor, we would like to ensure that everybody's view, including those who are bashful to us, is duly recognized. So we move for nominal voting. Now the chair can deny that. No, it's a waste of time. We have already seen the hands. And so that particular group can say, we move for reconsideration of the chairman's decision. And so, but again, you need 2/3 vote in order to overrule the chairman who is saying, wala na yung nominal voting. Sobrang matagal yan eh. Yun, mga ganong bakbakan. And that's where you see all of these things, these groups arguing. But you get a group of lawyers. Not all lawyers are good parliamentarians because they did not study this in law school. It is really through learning parliamentary procedure. I'll cite one very beautiful example. There was a board meeting and there was a minority stockholder who was making life very difficult. And he brought in some lawyers and he says, I hold certain shares of stocks. I am assigning 1 share of stock to this lawyer and to this lawyer so they can attend, you know, as proxies in this meeting. And obviously, it is not that they can vote. They can speak up and they can filibuster. And being lawyers, they can cite a lot of provisions in the corporation code that can hamper the proceedings. And it was at that point that I said, Mr. Chairman, the nature of proxy voting is provided for because the principal cannot attend. And so that therefore, when the principal here is present, he cannot be attending for himself for say 100 shares. But out of 100, he removes 2 shares and give to his friend and say, you are attending for me as my proxy for my 1 vote. No, because he is personally present and is capable of voting not only for his 98 shares but for his 2 shares. Okay. But you know, these are 3 veteran lawyers and said, we object to your position. And so that therefore, in other corporations where we attend, we can be proxy votes of stockholders who are also present. And I said, I do not agree with that one. And what will happen now? You are in a deadlock. Of course, the chairman and I already anticipate this. So I said, Mr. Chairman, in order for us to resolve this, let us now therefore divide the House. Yeah, that's a very technical term, divide the House. Beautiful to listen in parliamentary procedure. But what it simply means is, let us now vote. And obviously, the chairman is the controlling stockholder. So the moment he makes a decision, and then it is challenged, he casts his vote, and he is the controlling stockholder. Therefore, everybody will be beaten on his decision. And so he cast his vote and said, these proxies are overruled in these proceedings. You know, the other lawyers, no matter how veteran they are, coming from leading law firms, could not do anything because it was a decision of the chairman of the board himself. And you know, at this point, they were a little belligerent. And so I again moved that, Mr. Chairman, may I move for a declaration of a 15-minute recess so that we can call the security guards and escort anyone in this in this stockholders meeting who have no reason to be here. Kaya napahiya sila, you know, because ayaw naman nila tatawagin na may security guard that they will be physically pulled, you know. These are some of the excitements that you have. And when you are talking about corporate dealings, you need to be very smart in parliamentary procedure. So, that's a long story on the election by ballot. It doesn't always follow that a casting of votes by ballot is necessary or always mandatory. Casting vote for a director. In stock corporations, stockholders entitled to vote shall have the right to vote the number of shares of stock standing in their own names in the stock books of the corporation at the time fixed in the bylaws or where the bylaws are silent at the time of the election. The said stockholder may, letter A, vote such number of shares for as many persons as there are directors to be elected. Letter B, accumulate said shares and give one candidate as many votes as number of directors to be elected multiplied by the number of shares owned. Or letter C, distribute them on the same principle among as many candidates as may be seen. I have tried to figure out how to explain this to you for you to appreciate. And so let us take a look at this tabulation. I do not know whether I can ration off the showing, but let's take a look. Let's take a look first at the one on the left. It says shares, and there are 10 shares. And the directors would be 5 to be elected upon. And so the total votes to be cast would be the 10 shares multiplied by 5 directors. The 10 shares refer to a stockholder. And it says, provided that the total number of votes cast, meaning by a stockholder, shall not exceed the number of shares, which is 10, owned by the stockholders as shown in the books of the corporation, multiplied by the whole number of directors to be elected, which is 5. So for a particular stockholder, he can have 10, and there are 5 directors. He have 50. He has a strength of 50 votes that he can cast. Now let us say that there are these nominations that were made. Si Cardo Dalisay, Diana Olegario, Roxanne Opeña, Alessandra Romero, and Therese Padua. I hope you remember, for those of you who are matching Provinciano and Cardo Dalisay, these are familiar names to you. Now, let us find out how these 10 votes will be distributed according to what they call this the evenly spread. Because, for example, Dean Bisquera has 10 shares and there are 5 directors. He has 50 shares to cast. And on letter A, when he evenly spreads the 50 shares, there are 5 candidates, and so he can evenly say 10 for you, Dalisay, 10 for you, Diana, 10 for you, Roxanne, 10 for you, Alessandra, and 10 for you, Clarice. So if we total, that's 50, evenly spread. Or the second option, he can cumulate and say, I want Diana Olegario to win. And so I will cast my 10 votes, my 50 votes, all for Diana Olegario, cumulative. So I have a 0 vote for Dalisay. I have 50 votes for Olegario. I have 0 votes for Roxanne. I have 0 votes for Alessandro Romero. And I have 0 votes for Clarice. So here, there will be a very significant effect on Diana Olegario's election because the others are 0 and she's getting all of the votes of this stockholder. Now, the third one is, it is not evenly distributed. The voting stockholder now will pick up, for example, says, I do not like Dalisay, I do not like Clarice Padua, but I like Olegario, Roxanne, and Alessandra. But my favorite is Diana. So out of the 50, I give 20 to Diana, I give 15 to Roxanne, and I give 15 to Alessandra. That's supposed to be also a total of 50. And so those are the 3 mechanisms by which the number of votes entitled by a stockholder is cast. It says here, provided, says, however, that no delinquent stock shall be voted. Yan. So delinquent stocks are not qualified to be nominated. Unless otherwise provided in the Articles of Incorporation or in the bylaws, members of non-stock corporations may cast as many votes as there are trustees to be elected, but may not cast more than 1 vote for 1 candidate. Ayan, hindi pala pwede yung ginagawa dito sa stock corporation pagka non-stock. Nominees for directors or trustees receiving the highest number of votes shall be declared elected. Obviously, di ba, no? Okay. So, let's move on. Here now, we say no election. Is it possible? Yes, there are so many corporations that get into trouble because the controlling stockholders do not want to be replaced in the board. And so, they postpone the election. And so what does the corporation code provide? If no election is held or the owners of majority of the outstanding capital stock or majority of the members entitled to vote are not present in person, by proxy, or through remote communication or not voting in absentia, in other words, there is no quorum at the meeting, such meeting may be adjourned. And the corporation shall proceed in accordance with Section 25 of this code. We are just on Section 23, so we will wait for that. This was the provision in the original, in the Corporation Code of 1980. Now, assuming there is an elected director to perform his duties, the directors or trustees elected shall perform their duties as prescribed by law, rules of good corporate governance, and bylaws of the corporation. And here, candidates receiving the highest number of votes shall be declared elected. We also said that we are just reiterating that particular principle. We already see this particular signal. So let us go back to the setup. So we already took up the board of directors, the election of the board of trustees. We are now going into the corporate officers. After the board has been elected, then among the board of directors, they can now elect the corporate officers. In fact, among themselves, they can elect now who's chairman, who's vice chairman, etc. And they will now also elect for the corporate officers. such as immediately after the election, the directors of a corporation must formally organize and elect. And here are normally the positions to be elected as minimum. You elect the president, who must be a director. Then you elect a treasurer, who must be, this one must be a resident of the Philippines. Because can you imagine, that person is handling the finances, the money, and if that person is outside of the country, it will be very inconvenient to mobilize your funds. And the treasurer this time may or may not be a director. So this opens up a career where a good finance man who is not a stockholder and therefore not elected as director can still be part of the board elected as treasurer. And such other officers as may be provided in the bylaws, as secretary or as other officers. And there is a compliance officer. If the corporation is vested with public interest, then there is a need to elect a compliance officer. Now, if a secretary is elected, he shall be a resident and a citizen of the Philippines. I wanted to say something on this, but it will prolong a little. Like, if you have positions that are vice presidents, and therefore this can come up in labor cases, especially on illegal dismissal. Vice president siya, tinerminate siya. No? At sasabihin yan ba subject to employer-employee relationship. The celebrated case here is no less than that very brilliant lawyer by the name of Rufino Tan, the executive vice president of PSBA. At a certain point, he was not elected, he was not re-elected as executive vice president, so he lost his position in the board and somehow also his administrative positions. So he sued for illegal dismissal before the labor arbiter. And the decision of when the decision reached the Supreme Court, the case reached the Supreme Court said, Attorney Tan, your position as executive vice president is an elective position by reason of your being in the board. And therefore, you do not have an employer-employee relationship insofar as your being executive vice president is concerned. When you were not elected as executive vice president, your term has expired. So there was no illegal dismissal on the part of Attorney Paulino Tan. And Paulino Tan is a graduate of the UE College of Law, and in one of those meetings, board meetings I was attending, when the roll call was made, I was surprised when the person on my left was addressed as Attorney Paulino Tan to manifest his presence. And when I heard his name, I looked at him and said, Sir, are you the famous Paulino Tan who has that celebrated case in PSBA? Yes, I am. And I said, I am your ardent fan. I memorized your case when I took the bar examination. He was smiling, but we were having a meeting. After the meeting, nagkwentuhan kami at kinuwento niya sa akin yung buong-buo. Tuwan-tuwa naman ako because in addition to what I learned in the decision of the Supreme Court, meron palang personal component yun at meron pang nangyari not within the confines of the case. No? So, tuwan-tuwa ako at naging kaibigan ko siya. No? And I'm very proud to have met him because once upon a time, I was teaching accounting at the PSBA, and they were the big bosses among the hierarchy. The same person may hold two or more positions concurrently, except that no one shall act as president and secretary or as president and treasurer at the same time, unless otherwise allowed in this revised code. Take note at the University of Manila, the president is not the secretary. Dr. Emily Dodson de Leon is president and chief academic officer, not secretary, not treasurer. In the case of the chairman of the board, Dr. Monet de los Santos, she is chairman of the board and at the same time treasurer. And there is no conflict on that in the corporation code. These are the provisions under the Corporation Code of 1980. The officer shall manage the corporation and perform such duties as may be provided in the bylaws and or as resolved by the Board of Directors. And this is again another carryover provision just to show you that there is an existing provision along the same subject matter in that thing. Okay? So, we have our signal there that we now move to the master schedule. We now are to go to the report of election of directors, trustees, and officers, non-holding of election and cessation from office. Report of election of directors, trustees, and officers, non-holding of election and cessation from office. Within 30 days after the election of the directors, trustees, and officers of the corporation, the secretary or any other officer of the corporation shall submit to the Securities and Exchange Commission the names, nationalities, shareholdings, and residence addresses of the directors, trustees, and officers elected. The non-holding of elections and the reasons therefor shall be reported to the Commission within 30 days from the date of the scheduled election. The report shall specify the new date for the election, which shall not be later than 60 days from the scheduled date. So if today, for example, June 11 or June 10, for example, and the election was scheduled and there was no election because there was no quorum, there will be a new election date that we set up, which cannot be later than 60 days. So you count 60 days. For example, that's about 2 months. That means from June 10 to July 10, and then from July 10 to August 10. You know, so you have to have a firm schedule of the subsequent election so that the set of directors will not be hanging in the air. If no new date has been designated, or if the rescheduled election is likewise not held, the Commission may, upon the application of a stockholder, member, director, or trustee, and after verification with the unjustifiable non-holding of the election, summarily order that an election be held. So SEC can order an election. The Commission shall have the power to issue such orders as may be appropriate, including other directing the issuance of a notice stating the time and place of the election, designated presiding officer, and the record date or dates for the determination of the stockholders or members entitled to vote. Well, here, you can imagine what if the president did not want to call the meeting. It is because he doesn't want to be ousted. And so if you report that to the SEC now will designate another person who will act as chairman of that election of the board of directors. The shares of stocks or membership represented at such meeting and entitled to vote shall constitute a quorum. For purposes of conducting an election under this section, despite any contrary provision of the Articles of Incorporation or bylaws. Take note, it says the shares of stock represented in such meeting. It was not defining majority of the stockholders. Basta may umattend, yun na raw ang quorum. No? Kasi posibleng it is the majority that doesn't want to hold the election because they do not want their elected incumbent board to be ousted. Continuing now, should a director, trustee, or officer die, resign, or in any manner cease to hold office, the secretary or the director, trustee, or officer of the corporation shall, within 7 days from knowledge, not form, from knowledge thereof, report in writing such fact to the SEC. Well, there is a similar provision in the in the previous election code, and we are having here our signal to go back now to our matter. So under Articles 26 on the disqualification of directors, trustees, or officers, We now take a look at Section 26 of the Revised Corporation Code. It says, a person shall be disqualified from being a director, trustee, or officer of any corporation if within 5 years prior to the election or appointment as such the person was convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years, for violating this code and for violating Republic Act 8799, otherwise known as the Securities Regulation Act. This is something to do with allowing shares of stocks to be offered for the public under, for example, through a stock exchange. And B, found administratively liable for any offense involving fraudulent acts. So any person who in effect is accused of committing fraud is disqualified to be a director. Letter C, punished by a foreign court or equivalent foreign regulatory authority for acts, violations, or misconduct similar to those in paragraphs A and B. So the person may be doing business abroad and he may even be based abroad. But if he desires to be a director, he should not also be convicted by final judgment or found administratively to be committing fraudulent acts abroad. So the rule on committing an offense and also committing fraudulent acts does not only limit itself to actions within the Philippines, but would also cover actions that were done, for example, in the United States or any other country where this person could have been doing business. The foregoing is without prejudice to qualifications or other disqualifications which the Commission, the primary regulatory agency, or the Philippine Competition Commission may impose in its promotion of good corporate governance or as a sanction in its administrative proceedings. And so we now move over again to our chart and says removal of directors or trustees. How do we remove this director that has been elected, duly elected? Any director or trustee of a corporation may be removed from office by vote of the stockholders. Take note, stockholders holding or representing at least 2/3 of the outstanding capital stock, or in a non-stock corporation by at least 2/3 of the members entitled to vote. Such removal shall take place either at a regular meeting of the corporation or at a special meeting called for the purpose, and in either case after previous notice to stockholders or members of the corporation with the intention to propose such removal at the meeting. A special meeting of the stockholders or members for the purpose of removing any director or trustee shall be called by the Secretary on order of the President or upon written demand of stockholders representing or holding at least majority. This time it is not 2/3, but only majority of the outstanding capital stock or a majority of the members entitled to vote. If there is no secretary or the secretary despite demand fails or refuses to call the special meeting or to give notice thereof, the stockholder or member of the corporation signing the demand may call the special meeting or give notice thereof by directly addressing the stockholders or members. Notice of the time and place of such meeting. Allow me to move my picture somewhere else so you can see. The notice of the time and place of such meeting, as well as of the intention to propose such removal, must be given by publication or by written notice prescribed in this code. Removal may be with, take note, or without cause, provided that removal without cause may not be used to deprive minority stockholders or members of the right representation to which they may be entitled under Section 23 of this code. Okay? Continuing now. Under vacancies, this one is removal. Now here we talk about the vacancies in the Office of Director or Trustee, Emergency Board. Vacancy of Directors or Trustees and the Emergency Board. Any vacancy occurring in the Board of Directors or Trustees other than by removal or expiration of term may be filled up by the vote of at least majority of the remaining directors. So the directors themselves, let's say you have 5, one of them, one position was vacant, then the remaining directors, if they still have a quorum, kasi kung 4, dapat may quorum of at least 3. Diba? Otherwise, said vacancies must be filled up by the stockholders or members in a regular special meeting called for that purpose. So if you have 5 directors and 2 positions are vacant, the 3 may still be a quorum, may still be a quorum out of 5, and so they can still vote. But if there are only 2 remaining, then it will be the stockholders who will fill up the vacancy of 3 in a meeting, regular meeting or special meeting called for the purpose. When the vacancy is due to term expiration, the election shall be held no later than the day of such expiration at a meeting called for that purpose. When the vacancy arises as a result of removal by the stockholders or members, the election may be held on the same day of the meeting authorizing the removal, and this fact must be so stated in the agenda and notice of said meeting. So, if the board of directors were to remove, for example, the director, then they should also at the same meeting now, as a continuation, elect for the replacement. In all other cases, the election must be held not later than 45 days from the time the vacancy arose. A director or trustee elected to fill vacancy shall be referred to as replacement director, or trustee elected to fill a vacancy shall be referred to as replacement director or trustee and shall serve only for the unexpired term of the predecessor in office. A director or trustee elected to fill vacancy shall be referred to as replacement director or trustee and shall serve only for the unexpired term of the predecessor in office. And when the vacancy prevents the remaining directors from constituting a quorum and emergency action is required to prevent grave, substantial, and irreparable loss or damage to the corporation, the vacancy may be temporarily filled from among the officers by the corporation by unanimous vote of the remaining directors. Yan pala ang solusyon dyan. Okay. Now, continuing now. The action by the designated director or trustee shall be limited to the emergency action. Yung officer, president, or usually president is a member of the board. Pero you may have a vice president for marketing or a vice president for finance, no? Or manufacturing, and he can be elected unanimously. But the action by such director or trustee shall be limited to emergency action necessary, and the term shall cease within a reasonable time from the termination of the emergency or upon election of the replacement director or trustee, whichever comes earlier. The corporation must notify the Commission within 3 days from the creation of the emergency board, stating therein the reason for its creation. Any directorship or trustee to be filled up by reason of an increase in the number of directors. So from 5, ginawang 7 by the amendment of the Articles of Incorporation and bylaws shall be filled only by an election at a regular or special meeting of the stockholders or members duly called for the purpose, and in the same meeting authorizing the increase of directors or trustees if so stated in the notice of meeting. In all elections to fill vacancies under this section, the procedures set forth in Section 23 on the election of directors or trustees and Section 25 on the report of election of directors, non-holding of election, and cessation from office of this code shall apply. Well, we now again go back to our master schedule, and we are now about to talk about compensation of directors. Ito, I was shocked. Wala palang sweldo ang directors. And let's take a look. Compensation of directors. The directors or trustees shall not receive any compensation in their capacity as directors, in the absence of any provision in the bylaws fixing their compensation except for reasonable per dimes. Paano kung binigay naman na reasonable per dime 20 pesos per meeting? Kaya may mga secretaries, no? Cabinet secretaries, they attend, they are in the board of directors of, for example, 50 corporations under their department. O a-attend lang sila. Meron na kagad silang 50,000 pesos. So mas malaki pa sinisweldo nila kesa sa regular sweldo nila by membership in this board. This has already been discovered, and there was one time one president already said, "You stop doing that already." Pero yun ang hanap buhay ng mga executives sa government. They become members of the board of directors. A-attend lang, magmimerienda, magdi-dinner, mag-ano. Minsan, 30 minutes, hello, hi, o yun, meron na kagad silang 50,000. The stockholders representing at least a majority of the outstanding capital stock or majority of the members may grant directors or trustees with compensation. Ayan. Pagka majority ng capital stock pumayag, then pwede may compensation yung director and approve the amount thereof at a regular or special meeting. In no case shall the total yearly compensation of directors exceed 10%. O yan, may ceiling, may maximum of the net income before income tax of the corporation during the preceding year. So kung director ka ng 2021 at bibigyan ka ng compensation, the compensation cannot exceed 10% of the net income before income tax of the prior year, which is 2020, for your 2021 compensation as director. The directors or trustees shall not participate in the determination of their own per diems or compensation. Can you imagine? Kasali ka. Sabi, gusto ko ang allowance, ang compensation ko, 100 per meeting. Hindi pwede yun. Directors or trustees shall not participate in the determination of their own per diems or compensation. Corporations vested with public interest shall submit to their shareholders and the Commission an annual report of the total compensation of each of their directors or trustees. Corporations vested with public interest shall submit to their shareholders and the Commission an annual report of the total compensation of each of their directors. And so, continuing now, we now go into liability of directors, trustees, and officers under Article 30. Well, this is the original provision under Section 31 of the Corporation Code. But this is not what we are interested in. We are interested in, I'm sorry, I think we must have missed something. Let me just go back to it later. But let's continue with this particular thing, dealings of directors or trustees with the corporation. A contract of a corporation with one or more of its directors. So, director ka, and you are entering into a contract with the corporation where you are a director. Or a trustee or officer or other or their spouses and relatives within the fourth civil degree of first cousin, no? Either by consanguinity or affinity is voidable at the option of such corporation unless all the following conditions are present. Naunang lumabas yun, pero dapat ito muna. No? The presence of such director or trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum for such meeting. Second, the vote of such director or trustee was not necessary for the approval of the contract. Third, the contract is fair and reasonable under the circumstances. And fourth, in case of corporation vested with public interest, material contracts are approved by at least 2/3 of the entire membership of the board, with at least a majority of the independent directors voting to approve the material contract. Now, the continuation, it says, where any of the first three conditions, A, B, and C, yung presence of trustee to constitute a quorum, yung vote of the trustee in order to approve the contract, and the question of fairness and reasonableness, sabi, where any of the first three is absent, any, in case of a contract with a director or trustee, such contract may be ratified. Hindi naman pala illegal, ratified by the vote of the stockholders. Now you go to the owners, representing at least 2/3 of the outstanding capital stock, or at least 2/3 of the members in a meeting called for the purpose, provided that full disclosure of the adverse interests of the directors or trustees involved is made at such meeting and the contract is fair and reasonable under the circumstances. Talagang dadaan ka sa butas ng karayom kung ikaw ang director at ikaw din yung nakikipagkontrata dun sa sarili mong korporasyon. Continuing now, the dealings of directors, the contract between corporations with interlocking directors. Napag-usapan natin yung dealings with directors. Ito, punta tayo, contracts between corporations with interlocking directors. It says, except in cases of fraud and provided the contract is fair and reasonable under the circumstances, a contract between two or more corporations having interlocking directors shall not be invalidated on that ground alone. So, dalawang korporasyon, no? Yung director ng isang korporasyon, director din ng kabilang korporasyon. Kaya interlocking directors. The fact na yung dalawang korporasyon na yon engaged into contract, yung isa ay supplier, yung isa naman ay customer, no? The fact na pareho ang director nila doesn't mean invalid yung kontrata nila on logistics or supply. If the interest of the interlocking director in one corporation is substantial and the interest in other corporation is merely nominal, the contract shall be subject to the preceding section insofar as the latter corporation or corporations are concerned. So, hindi invalidated, lalo na kung yung interest ng interlocking director doon sa supplier corporation, substantial, pero doon naman sa customer corporation, director nga siya, pero maliit lang ang kanyang what we call this interest. Okay. Stockholders exceeding 20, yan, stockholdings exceeding 20% of the outstanding capital stock are considered substantial for purposes of interlocking directors. So kung may-ari ka ng 20%, yun substantial na yun. Okay. And then we go now to disloyalty of a director. It says, when a director by virtue of such office acquires a business opportunity which should belong to the corporation, thereby obtaining profits to the prejudice of such corporation, the director must account for and refund to the latter all such profits unless the act has been ratified by a vote of the stockholders owning or representing at least 2/3 of the outstanding capital stock. So here it envisions the director, no, is starting to also go on his own personal transactions, and he happens to have encountered a business opportunity, pinasukan niya. Now, tama ba yun? Ang tanong doon is, if that business opportunity should have been given to his corporation, either to solicit, to sell to that corporation or to buy to that corporation, if he entered into that without clearing it with his corporation, if he made profits on that, he's supposed to turn that over to the corporation. No? Ngayon, pero kung sakaling ginawa niya, pero ano naman siya, controlling stockholder siya, he controls 2/3. No? If that particular action is ratified by 2/3 of the stockholders, then there is no problem at all when he now takes that kind of opportunity. Kasi kung 2/3 ka na, edi nalulugi ka din doon sa niloloko mo yung korporasyon mo. This provision shall be applicable, notwithstanding the fact that the director risks one's own funds in the venture. Hindi niya pwedeng sabihin, pinasukan ko nga yung business na yun, pera ko naman yung ginamit ko, ba't gusto niya yung tinubo doon, ibibigay ko sa corporation. And ang sagot therefore is, kahit na pera mo ginamit mo, na dapat binigay mo opportunity, wala kaming pakialam, lahat na itinubo mo, i-turn over mo sa corporation. Babayaran niyo ba ako sa kapital ko? Ang sagot, hindi. Okay. Tiers of conflict of interest. Saan nagkakaroon yan? Tawag conflict of interest. Conflict between a board member and the company. Board members' duty of loyalty to stakeholders of the company is compromised. Third, interest of stakeholder groups are not appropriately balanced or harmonized. And finally, conflicts are those between a company and society and arise when a company acts in its own interest at the expense of society. And then finally, yung tinatawag natin na executive, management, and other special committees. The board may create an executive committee if the bylaws so provide composed of at least 3 directors. Said committee may act by majority vote of all of its members on such specific matters within the competence of the board, as may be delegated to it in the bylaws or by majority vote of the board except with respect to approval of any action for which shareholders' approval is also required. Here is what we call corporate acts of ownership, not administration. Letter B, the filling of vacancies in the board that cannot be handled by the executive committee. C, amendment or repeal of bylaws or the adoption of new bylaws. Why? Again, corporate acts of ownership yan, hindi administration, and the executive committee cannot handle that. Letter D, amendment or repeal of any resolution of the board which by its express terms is not amendable or repealable. Siyempre, executive committee lang, i-overrule mo pa yung board mo. Okay. Letter E, distribution of cash dividends to stockholders because the board can decide on distributing cash dividends, but that cannot be inherited by way of practicing that by the executive committee. The board of directors may create special committees of temporary or permanent nature and determine the members' term, composition, compensation, and powers and responsibilities. And so, my dear friends, we have covered the provisions of the revised corporation code covering the board of directors. And let me again reiterate that this particular lecture, this particular sharing on the corporate board of directors, I pay tribute to my superiors, to my associates, to my fellow workers at the University of Manila, headed by Dr. Emily Dadson de Leon, the President and Chief Academic Officer, and Dr. Maria Ramona Corazon de los Santos, Chairman of the Board, Controlling Stockholder, and Vice President Treasurer, and to my friend Attorney Diosdado Madrid. Just to close this session on the Board of Directors for a corporation under the Corporation Code, let me take this opportunity to recognize the hard workers in the University of Manila. Dr. Emily Dadson de Leon is the prime mover of UM. He has been there in the toughest history of UM in the 60s and 70s when violent demonstrations and activism was present. Dr. Emily Dadson de Leon would reminisce that even if she were a lady, a mestiza, she would be the one to be in front of all the activist students to pacify them and to get them out so that they don't ruin the university and create confusion and havoc inside the university. I have worked with Dr. Emily Dodson de Leon from 1994 when I became a law professor and a bar reviewer. But I had no opportunity to directly work with her until 2004, 10 years after, when her combined effort with the chairman of the board and the president Dr. Virgilio de los Santos, insisted that I assume the leadership of the College of Law of the University of Manila. And Dr. De Leon happens to be the chief academic officer, and as the dean, I report directly to her. I have seen her in close range, and I have worked with a lot of very hardworking executives. But Dr. De Leon is one person who really shocks me with her immediate action. When she encounters a problem, she does not delegate or relegate the problem. She immediately is on the rise and action it personally. That is why there is no problem, there is no issue, there is no difficulty in the University of Manila where Dr. De Leon is not involved in. She is so active likewise in interfacing with the students that I have seen with my own two eyes. Pupunta ka sa police station, papakilala ka na din ng College of Law. Pag narinig University of Manila, ang una kagad tanong, Sir, graduate po ako ng criminology ng UM. Kumusta po si Ma'am Emily De Leon? My God, yung mga pulis na nag-aral ng criminology sa UM, lahat ang kilala nila at mahal nila si Dr. Emily Dodson De Leon. Kakain ka sa 5-star hotel, makikita mo yung mga matataas ng posisyon na sa food and beverage, magagandang mga dalaga. Tatanungin mo, ikaw ba'y graduate ng Hotel and Restaurant Management? Opo sir, siya ka-graduate University of Manila. Tinatanong ko, ako din ng College of Law ng UM, hindi ako kilala. Tapos sasabihin ko, taga UM ako. Sir, kumusta po si Dr. Emily De Leon? Bakit? Nung nandun po kami, nagiging teacher pa po namin siya. Siya po nagtuturo sa amin. My God. And side by side with her is of course Dr. Monet de los Santos. Very hardworking, very loyal to UM. And of course, my dear friend Diosdado Madrid. Also absolutely committed to the University of Manila for more than 40 years. Kaya po ako, 27 years, baliwala po ang aking track record sa UM sapagkat mga ito po nagbibilang ng 40 years at 50 years para pong yung buong buhay na nila talagang University of Manila. And that's why I am very proud to be working with them. I have been with them in the best moments of University of Manila, and I have also been with them in the worst case, including the death of our own chairman, Dr. Virgilio de los Santos. So, Madam Emily, Dr. Monet, Attorney Madrid, allow me to thank you for giving me the opportunity to be accepted by you and to become part of the senior management of the University of Manila. Ngayon pong retired na ako sa corporate world, hindi na rin po ako pinatuloy ng De La Salle University. Isa na lang po ang aking employer, University of Manila. Nag-pandemic po, nagkataon, nag-iisa lang ako ngayon sa College of Law at sana naman mapagtiyagaan ng University of Manila at ang aking mga kaibigan, ang aking mga minamahal na JD students sa UM na nag-iisa si Dean Bisquera ngayon na umaalalay sa kanila. So Madam Emily, Dr. Monet, Atty. Diosdado Madrid. Thank you very much for giving me the opportunity. Kung mapanood nyo po to, salamat po naman sa pagtsatsaga nyo sa aking maliit na contribution and my dedication to the University of Manila. Salamat po. I love you and I will always be part of the team that will struggle and allow UM to survive forever. Thank you po.